The company made us download a new app. Health tracking, they said. For wellness, mandatory, they said. I used it for 6 months. Then HR sent an email. Come to the office. Now, 2 people were waiting. You're being terminated. I was shocked. Why? They opened a laptop. Numbers appeared on screen. 127. What did that mean? 127 times. In 6 months. 8 minutes each. 18 hours total. 127 what? Bathroom breaks. The app recorded it. GPS tracking. Every break, every second. Time theft. But I had a chronic condition. They knew that. Doesn't matter. Numbers don't lie. I found a lawyer. We looked at the files. I wasn't alone. 340 more people. Same reason. Pregnant women. Sick people. Elderly workers. An app had fired them all. My name is Holden Reed. I'm 38 years old. And going to the bathroom had destroyed my life. Let me take you back 18 months. I was working as a data analyst at Tech Vantage Solutions in Austin, Texas. Mid-sized company. About 800 employees. Good job. Decent pay. Health insurance. Standard corporate environment. I'd been there 5 years. Good performance reviews. No disciplinary issues. Normal employee. In January, the company announced a new initiative. Employee Wellness Program 2.0. They sent company-wide emails. Excited language about improving our health. Reducing healthcare costs. Creating a culture of wellness. The centerpiece was a new app, Vital Track, developed by a wellness tech startup. The app would monitor various health metrics, steps taken, heart rate, sleep quality, activity levels, all synced to our phones. The company presented it as optional at first, encouraged but not required. They offered incentives. Use the app consistently and get lower health insurance premiums. Hit certain activity goals and earn gift cards. Standard corporate wellness program stuff. I didn't think much. Seemed harmless. Maybe even helpful. I downloaded VitalTrack in February. Set up my profile. Connected my phone's health data. Started tracking steps. The interface was clean. Simple. It showed daily step counts, activity minutes, sleep duration, basic wellness metrics. Nothing invasive. Nothing concerning. By March, the app had become mandatory. Company sent an email. All employees must have VitalTrack installed and active. Must maintain at least 60% compliance, meaning the app needed to track you actively 60% of work hours. Failure to comply would result in disciplinary action up to termination. The justification was insurance. The company had negotiated lower health insurance rates, but the insurance company required proof of wellness program participation. So VitalTrack became mandatory. Most employees grumbled but complied. What choice did we have? Jobs aren't easy to find. Health insurance matters. We downloaded. We activated. We carried our phones everywhere. The app ran in the background. Always tracking. Always monitoring. I have Crohn's disease. Have had it since my 20s. It's a chronic inflammatory bowel condition. Causes frequent bathroom needs. Unpredictable urgency. Sometimes multiple times per hour. I disclosed this to HR when I was hired, provided medical documentation, was told it wouldn't be a problem. The company was ADA compliant, would provide reasonable accommodations. For 5 years that had been true. No issues, no complaints. I did my job well, took bathroom breaks as needed. Nobody cared. Then VitalTrack started. I didn't think about how it might track bathroom breaks. The app was supposed to monitor health metrics, steps, heart rate, not bathroom habits. But VitalTrack was more sophisticated than we knew. It used GPS, motion sensors, pattern recognition algorithms. It could tell when you were at your desk, when you were walking, when you were in the bathroom, how long you stayed. The app built profiles, learned patterns, created data models of employee behavior, all automatically, all in the background, all without our explicit knowledge. The privacy policy was 40 pages of legal language. Buried in Section 23, subsection C, was a clause. Location and movement data may be collected and analyzed for wellness optimization purposes. Nobody read it. Nobody questioned it. We just clicked accept and moved on. For 6 months, I used the app. Went about my normal routine. Worked. Took bathroom breaks as needed. Managed my Crohn's. Did my job. Nothing changed from my perspective. But the app was watching. Recording, analyzing, building a case against me. In August, I got the email. HR needs to see you. Conference room B. 2 p.m. today. Please bring your employee ID. I arrived at 2. Found 2 people waiting. Melissa from HR, and someone I didn't recognize, a man in a suit. He introduced himself as Robert Chen, legal counsel for TechVantage. My stomach dropped. Why was a lawyer here? Melissa spoke first. Holden, we need to discuss a serious matter. We've identified a pattern of time theft. Time theft? What? Our wellness monitoring system has flagged concerning behavior. Excessive non-work time during paid hours. I was confused. I don't understand. I work my full hours. I'm always here. Robert the lawyer opened his laptop, turned the screen toward me. A spreadsheet appeared. Columns of data. Dates, times, durations, locations. This is 6 months of VitalTrack data, he said. Your data specifically. Do you see this column? He pointed. The header read, bathroom visits. My heart started racing. The spreadsheet listed every bathroom break I'd taken. Every single one. For 6 months. 127 entries, each with a timestamp. A duration. A location marker showing I'd been in the building restroom. 127 bathroom visits, Robert continued, averaging 8.4 minutes per visit. Total time, 17.8 hours. That's more than 2 full workdays spent in the bathroom, on company time. This constitutes time theft. I couldn't believe what I was hearing. I have Crohn's disease. You know that. It's documented. I need frequent bathroom breaks. It's a medical condition. Melissa nodded. We're aware of your disclosed condition. The data shows excessive usage beyond reasonable accommodation. The average employee uses the bathroom 2.3 times per workday. You're averaging 4.2 times. That's 80% above normal. Because I have a chronic illness. That's what reasonable accommodation means. Robert shook his head. Reasonable accommodation doesn't mean unlimited non-productive time. It means we make reasonable adjustments. 4 bathroom breaks per day totaling over 30 minutes is not reasonable. It's excessive. Have I ever missed a deadline? Has my work quality suffered? Have I failed to meet expectations? That's not the point, Melissa said. The point is time theft. You're being paid for hours you're not working. The data is clear. They handed me termination papers. Effective immediately. Cause, time theft. Violation of company productivity standards. My 5 years, my clean record, my good performance, none of it mattered. An app had decided I was stealing time. I was escorted to my desk, given 15 minutes to pack personal items. Security watched me, like I was a criminal, like I might steal something. I left the building in shock, drove home in a daze, couldn't process what had happened. That evening, I started researching, looking for information about VitalTrack, about wellness app tracking, about legal rights. Found very little. VitalTrack was relatively new, not much public information, a few reviews, mostly positive. Great for corporate wellness, easy to use. Helpful tracking, nothing about invasive monitoring, nothing about employees being fired. I contacted a lawyer the next day, employment attorney named Sarah Kim, explained what happened, showed her the termination papers, the data spreadsheet. She listened carefully, took notes, finally spoke. This is disability discrimination, clear ADA violation. They fired you for a symptom of your disability. That's illegal. Can we fight it? Absolutely. And I suspect you're not the only one. Companies using these monitoring apps often fire multiple people. We should look into whether there are other victims. She was right. We filed a formal complaint, requested discovery. Company was required to produce documents, employee termination records, VitalTrack data reports. The results were staggering. In 6 months, TechVantage had terminated 340 employees, all for time theft, all based on VitalTrack data, all for excessive bathroom breaks. The victims were predictable. Pregnant women, employees with diabetes, older workers with prostate issues, people with IBS, anyone with a medical condition requiring frequent bathroom use. The company had systematically fired them, used the app duty as justification, claimed it was legitimate productivity concerns. But it was discrimination, pure and simple. The VitalTrack system had been designed with efficiency metrics, algorithms that flagged non-productive time. Bathroom breaks exceeding certain thresholds triggered alerts. HR received automated reports. Employees who crossed certain lines were tagged for termination. Nobody at the company questioned it. The data said these employees were stealing time. That was enough. They never considered medical condition, never thought about ADA protections, never questioned whether an algorithm might be discriminatory. They just trusted the numbers. and 340 people lost their jobs. Sarah filed a class action lawsuit, got 340 former employees to join, all terminated for the same reason, all victims of the same system. TechVantage fought hard, claimed legitimate business reasons, argued that productivity standards apply to everyone, said medical conditions didn't exempt employees from basic expectations. Their lawyers argued that taking 30 minutes of bathroom breaks daily was objectively excessive, that no condition justified that much non-work time, that the company had every right to enforce productivity standards. Our lawyers countered, showed medical documentation, doctor letters explaining that conditions like Crohn's require frequent bathroom access, expert testimony about the ADA, about what reasonable accommodation actually means. The case went to trial. 3 weeks of testimony. Dozens of witnesses. Employees crying on the stand, describing their humiliation, their shock, their financial devastation. Pregnant women who'd been fired for morning sickness bathroom trips. Diabetic employees fired for insulin-related bathroom needs. Elderly workers fired for age-related prostate issues. All of them targeted by the same algorithm. All of them victims of automated discrimination. TechVantage's defense was cold. They presented data, charts, graphs, showed that these employees were statistical outliers, that their bathroom usage was significantly above average, that productivity had measurably declined. They argued this was about business, about efficiency, about ensuring employees earned their pay, not about discrimination, just about data-driven management. The jury didn't buy it, deliberated for 6 hours, came back with a verdict. Guilty of disability discrimination, guilty of ODA violations, guilty of wrongful termination. 340 counts. The damages were substantial. Back pay for all terminated employees, compensatory damages for emotional distress, punitive damages for willful discrimination. Total award, $87 million. TechVantage appealed. Lost. Appealed again, lost again, finally settled, agreed to pay the full amount, agreed to discontinue VitalTrack, agreed to implement new policies, agreed to train all managers on disability rights. The victory felt hollow. Yes, we won. Yes, we got money. But 340 people had lost jobs, careers interrupted, finances devastated, reputations damaged. Some had lost homes. Some had suffered severe anxiety and depression. Some had given up on corporate work entirely. Money didn't undo that. The case went to trial in federal court. Judge Patricia Anderson presiding. 3 weeks scheduled for testimony. Both sides brought extensive evidence. Our side presented first. Sarah Kim, our lead attorney, outlined the case. 340 employees, all terminated within 6 months, all for the same reason. Bathroom breaks flagged by VitalTrack. All had medical conditions. Pregnancy, diabetes, Crohn's disease, IBS, prostate issues, age-related conditions, all protected under ADA, all fired anyway. The jury listened intently, took notes, looked disturbed. First witness was Maria Gonzalez, 32 years old, 6 months pregnant when terminated. She testified through tears. I was having morning sickness, needed bathroom frequently. First trimester was rough. The app tracked every visit. HR called me in. Said I was taking too many breaks. I showed them my pregnancy documentation. They said it didn't matter. Data showed excessive non-productive time. I was fired at 6 months pregnant. Second witness was Robert Kim, no relation to our lawyer, 64 years old, type 2 diabetic. Diabetes affects bladder control. I needed frequent bathroom breaks, had for years, never been a problem. Then VitalTrack started. 6 months later, I'm called to HR. They show me a spreadsheet. Every bathroom visit, times, durations. Say I'm stealing company time. I tried to explain, showed medical records. They terminated me on the spot. 30 years with the company, gone. Third witness was Jennifer Walsh, 28, irritable bowel syndrome. IBS is unpredictable. Some days I'm fine. Other days I need bathroom access constantly. I disclosed this when hired. HR said it was fine. Reasonable accommodation, they said. Then the app started tracking. I didn't know it was monitoring bathroom breaks. 6 months later, I'm fired. For time theft, I lost my health insurance right when I needed it most. Witness after witness, same story. Medical condition. Disclosed to company. Accommodated for years. Then VitalTrack. Then termination. All within months. The pattern was unmistakable. TechVantage's defense tried to paint a different picture, argued these were legitimate productivity concerns, brought in their own witnesses, started with productivity metrics. An efficiency consultant testified, 18 hours of non-productive time over 6 months presents significant loss. That's 0.04 FTE, full-time equivalent. Multiply that by 340 employees, and you're looking at substantial productivity drain. Our lawyer cross-examined. You're aware all these employees had medical conditions? I was told there were some medical issues, yes. And that federal law requires reasonable accommodation? I'm not a lawyer. I analyze productivity data. So you're saying companies should fire sick people because they're less productive? Objection. Sustained. But the point was made. The jury saw it. You can't hide discrimination behind productivity numbers. TechVantage brought in the VitalTrack CEO. James Morris defended his technology. Our algorithm doesn't discriminate. It simply tracks time, records data, flags outliers. The analysis is completely objective. No human bias involved. Sarah Kim destroyed him on cross. But humans programmed the algorithm correct? Yes. Humans decided what thresholds trigger flags? Yes. Humans decided that bathroom breaks count as non-productive time? Well, yes, but. And humans decided not to build in exemptions for medical conditions? The algorithm treats everyone equally. Equally wrong when it comes to disabled workers, isn't that right? Objection. Overruled. Answer the question, Mr. Morrison. The algorithm follows productivity metrics. That's not an answer. Your algorithm systematically flagged disabled workers for termination. Yes or no? The algorithm flagged employees with high non-productive time. Who happened to be disabled? Who happened to be pregnant? Who happened to be elderly? Your algorithm is a discrimination machine, isn't it? Objection, Your Honor. I'll allow it. Mr. Morrison? He had no good answer. The algorithm was discriminatory. Whether intentionally designed that way or not, the effect was the same. Disabled workers were systematically targeted. We brought in expert witnesses. Dr. Rachel Foster, gastroenterologist, explained Crohn's disease, how it requires frequent bathroom access, how it's unpredictable, how it's protected under 80. Reasonable accommodation for Crohn's means flexible bathroom access. There's no way to predict when symptoms will occur. Telling someone with Crohn's they can only use bathroom twice per day is like telling someone with asthma they can only breathe twice per hour. It's medically impossible. Dr. Michael Zhang, endocrinologist, explained diabetes and bladder issues, how high blood sugar affects urination frequency, how this is a known complication, how it's uncontrollable. You cannot schedule diabetic bathroom needs. The body doesn't work that way. Firing someone for diabetic symptoms is clear disability discrimination. Dr. Sarah Williams, OBGYN, testified about pregnancy, morning sickness, increased urination frequency, how it's temporary but intense. Pregnant women need bathroom access. It's not optional. It's biology. Firing pregnant women for pregnancy symptoms violates both 80 and pregnancy discrimination laws. The medical testimony was overwhelming. These conditions require bathroom access. It's not laziness, not time theft, not choice. It's medical necessity. TechVantage couldn't refute it. Tried to argue that reasonable accommodation has limits, that even disabled workers must meet minimum productivity standards. But they couldn't explain why bathroom breaks automatically meant lower productivity. Couldn't show that any of these employees had failed to meet their actual job requirements. The bathroom usage was the only metric they cited, not work quality, not deadlines, not output, just bathroom time. That's discrimination, pure and simple. The trial's most powerful moment came during my testimony. Sarah Kim had me walk through everything: my hiring, my disclosure of Crohn's, 5 years of good employment, the VitalTrack rollout, the termination. Then she asked the key question. Mr. Reed, in your 5 years before VitalTrack, did anyone ever complain about your bathroom usage? No. Did you ever miss a deadline? No. Ever receive negative performance reviews? No. All my reviews were good to excellent. So, what changed? The app started tracking, quantifying, turning my medical condition into data points, making my disability visible in a way it hadn't been before. And that's when you became a problem? Yes, when I became a number instead of a person. TechVantage's lawyer cross-examined me, tried to make me seem unreasonable. Mr. Reed, isn't it true you took an average of 4 bathroom breaks per workday? Yes, because of my Crohn's disease. That's significantly more than the average employee. Yes, because I have a disability. Don't you think that's excessive? I think it's necessary and legally protected. But it does impact productivity, doesn't it? My productivity was never questioned before VitalTrack. My work was always completed on time, to standard. My bathroom needs didn't affect my output, but they did affect your time. Everyone's bodily functions affect their time. Some people take smoke breaks. Some take coffee breaks. I take bathroom breaks because I'm disabled. He had no response because there was no good response. The law was clear. ADA requires reasonable accommodation. Bathroom access for medical conditions is textbook reasonable accommodation. Firing someone for it is textbook discrimination. After 3 weeks of testimony, both sides rested. Closing arguments took a full day. TechVantage's lawyer argued this was about productivity, about fair application of standards, about ensuring employees earned their pay. These employees were taking excessive breaks. The company has a right to expect productivity. Medical conditions don't give unlimited license to not work. The accommodations requested were unreasonable. The company made a legitimate business decision. Sarah Kim's closing was powerful. This case is simple. 340 disabled workers were fired for symptoms of their disabilities. That's what happened here. The company hid behind an app, behind data, behind algorithms. But discrimination is discrimination, whether a human does it or a computer does it. Federal law protects disabled workers, requires accommodation. TechVantage ignored that law, used technology to systematically eliminate employees with medical conditions. That's illegal. That's wrong. And you have the power to make it right. The jury deliberated for 6 hours, came back with verdict. We stood as they entered. Judge asked the foreperson, "Have you reached a verdict?" "We have, Your Honor." "On the charge of disability discrimination under the ADA, how do you find?" "Guilty." "On all 340 counts?" "Yes, Your Honor. Guilty on all counts." The courtroom erupted. Crying, cheering. TechVantage's lawyers looked stunned. The judge restored order. "Ladies and gentlemen, this court will now move to the damages phase." Damages took another week. We presented evidence of harm, lost wages, lost benefits, emotional distress, medical bills. Some plaintiffs had lost homes, gone into depression, suffered severe anxiety. The company's actions had devastated lives. The jury awarded back pay for all 340 employees, averaged 2 years' wages each. That alone was $34 million. Then compensatory damages for emotional distress, averaged $50,000 per plaintiff. Another $17 million. Then the big one, punitive damages, meant to punish the company, deter future violations. The jury awarded $100,000 per count, 340 counts, $34 million in punitive damages. Total verdict, $87 million. TechVantage's stock price collapsed. They filed immediate appeals. Lost. Filed again. Lost again. Faced with paying the full amount they settled. Agreed to pay all $87 million. Agreed to discontinue VitalTrack mandatory usage. Agreed to implement new disability accommodation policies. Agreed to train all managers on ADA compliance. Agreed to never use bathroom tracking for employment decisions again. The victory was sweet, but complicated. Yes, we won. Yes, we got money. But 340 careers had been disrupted. Lives thrown into chaos. Some people had lost everything. Money helped, but it didn't undo the trauma. Didn't restore the years of stress. Didn't heal the emotional wounds. VitalTrack, the company, went bankrupt within 6 months. Our lawsuit destroyed their business model. No other company wanted to risk similar liability. Their technology became toxic. They shut down completely, laid off all employees, ceased operations. I used my settlement money to start over, took 6 months off, recovered emotionally, processed everything that had happened, then started freelancing, built a consulting business, work from home now, control my own schedule, no more corporate monitoring, no more wondering if every bathroom break is being judged. The freedom is incredible, but I'm angry, still angry. Angry it came to this. Angry that 340 people had to lose jobs before anyone cared. Angry that technology was trusted more than human judgment. Angry that an app nearly destroyed hundreds of lives. I speak publicly now, at conferences, at corporate events, warning about surveillance technology, about algorithmic discrimination, of the danger of trusting data over people. Companies listen because they're scared. Scared of lawsuits. scared of publicity, scared of becoming the next TechVantage. Good. They should be scared, because what happened to us can happen anywhere. Any company using monitoring technology, any algorithm making employment decisions, any system that treats humans as data points. It's all dangerous, all potentially discriminatory, all subject to the same laws that TechVantage violated. The wellness program was supposed to help us improve our health. Instead, it became a tool for discrimination, a way to identify and eliminate employees with medical conditions under the guise of productivity, under the cover of data-driven management. My name is Holden Reed. I'm 40 years old now. 2 years have passed since I was fired for going to the bathroom, since an app tracked my every visit, since VitalTrack recorded 127 bathroom breaks and decided I was a thief, since TechVantage terminated me for having Crohn's disease. The lawsuit changed everything, not just for me, but for workplace monitoring nationwide. After our verdict, dozens of companies discontinued bathroom tracking, removed GPS monitoring from wellness apps, implemented human review for all termination decisions. The case became precedent, cited discrimination lawsuits, used to challenge algorithmic employment decisions. Legal scholars wrote about it, called it a landmark case in the intersection of technology and civil rights. But I don't feel like a hero. I feel like a survivor, someone who was violated and fought back, who organized 340 other victims, who forced a reckoning. The emotional toll was enormous. Testifying about my medical condition in open court, having lawyers question whether my bathroom needs were legitimate, seeing my most private bodily functions reduced to data points on a spreadsheet. That stays with you, changes how you see yourself, how you navigate the world. I'm more cautious now, more protective of my privacy, more skeptical of corporate promises. When companies talk about wellness programs, I cringe. When apps request health data, I refuse. When employers talk about productivity optimization, I hear discrimination. Maybe that's paranoid. Maybe I'm damaged. But I've earned this wariness. I've seen what happens when companies treat employees as metrics, when algorithms make life-changing decisions, when efficiency trumps humanity. The 340 plaintiffs scattered after the settlement. Some retired early. Some changed careers entirely. Some stayed in corporate jobs, but with new awareness, new caution. We have a private online group. Share updates, support each other, remind ourselves we weren't crazy, that what happened was real, was wrong, was illegal. Some people ask if I regret not just accepting the termination, taking the loss, moving on quietly. After all, the lawsuit took 2 years, consumed my life, cost me emotionally. Maybe I'd have been better off just starting over. But no, I don't regret it. Because 340 people got justice. Because VitalTrack was destroyed. Because other companies thought twice about implementing similar systems. Because we proved that disabled workers have rights. That technology doesn't override those rights. That discrimination is still discrimination even when an algorithm does it. The settlement money changed my life practically, allowed me to work independently, build something on my own terms. But the real victory was forcing accountability, making a company pay for treating humans as data. The wellness app industry changed after our case. New regulations, new oversight, requirements for medical exemptions, limits on what employment decisions can be automated. It's not perfect. Monitoring still happens. Surveillance still exists, but there are guardrails now. Legal precedent, awareness that workers have rights even in the digital age. I speak at conferences now, tech ethics panels, employment law seminars, disability rights events. Tell our story, warn others. Some people are grateful, others are defensive. Say their systems are different, better. I always respond the same. That's what TechVantage said too. And 340 people still lost jobs. Technology is neutral, they say. Just data, just algorithms. But that's a lie. Technology embodies creator values, reflects biases, amplifies assumptions. VitalTrack assumed bathroom breaks meant theft, assumed productivity was time at desk, assumed everyone's body works the same. Those assumptions were wrong. Discriminatory. Cost 340 jobs, so I tell everyone. Question monitoring. Read privacy policies. Understand what's collected. Ask about accommodation, about human oversight. And if they say just trust the system, remember my story. Remember VitalTrack? Remember we trusted. We were wrong until we fought back, until we won, until we made sure it couldn't happen to others. That's my legacy. Not just winning a lawsuit, but changing how companies think about surveillance, about automation, about treating workers as humans rather than metrics. Is it enough? No. Monitoring continues. Algorithms still make decisions. Workers still have their bathroom breaks tracked. But there's awareness now, legal risk, precedent, and 340 people who know they have rights, who know they can fight back, who know that being disabled doesn't mean being disposable. That's worth everything we went through. Every moment of stress, every hour in court, every time I had to explain my medical condition to strangers, because we proved something important. That humanity matters more than efficiency, that bodies aren't machines, that disabled workers deserve dignity, and that no app, no algorithm, no productivity metric can override basic human rights. My name is Holden Reed. I'm 40 years old, and I went to the bathroom 127 times in 6 months. Each time judged until I fought back and won.